Well, good morning, everyone. On behalf of the partners and the lawyers and the staff of Borah, Goldstein, Altschuler, Nahins, and Goidel, we welcome you to this seminar dealing with the legislation that was passed up in Albany just a couple of weeks ago. I'm Bob Goldstein, by the way, to those of you who don't know me. I've been doing this for somewhere close to 45 years, and I got my start back in 1974, just when they had passed the ETPA. There was a 3-year period between 1971 and 1974 where you had vacancy decontrol. The legislature quickly closed that gap, and then from 1974 on, it's been a fight to try to lessen the reins of the rent regulatory system as it affects owners. And for a great many years, progress was made. In 1983, the law was changed as to get us under the wings, or should I say the talons, of the DHCR. And we can see now that since the Democrats took over the state Senate, that what's come out of it is even worse than what a lot of us had predicted. I'm here to moderate. I have a couple of topics that I'm going to talk about, and then I'm going to turn this over to other partners of the firm. Please hold your questions. There are cards to fill out if you have a question. Time constraints are going to be difficult for us to meet because there are a lot of topics that need to be covered. And so the first topic that I'm going to deal with right now is the issue of the expiration provision of the law. What the Democrats did was very, very clever. They passed these bills so that the regulatory system became perpetual. In other words, the legislature doesn't have to act anymore. In order for these laws to be repealed, it would require the agreement of the Senate, the Assembly, and the governor. What that means is even if the Republicans retook control of the state Senate, they would not, unless it was part of a broader deal between them and the Democrats and the governor, be able to affect any change in the law. So this has placed everyone in a very, very difficult position. The hope that next year they take control of the Senate will make a difference is an illusion unless it's dealt with in a different way. So we have a law now that technically is supposed to go on forever. Now there's a downside for the Democrats and the tenants advocates on that, and that is that one of the bases upon which rent regulation has been found constitutional is that it's dealing with an emergency, and the emergency does not go on forever, at least in theory. So that by making this without a sunset provision, they've pretty much put themselves in a position where it's possible that a judge in either the state or the federal court could say, you want to know something? That part of this is no good. Okay, so assume that happened. Well, then they just go back into session, they pass another law and said, okay, it'll sunset in 5 years or 6 years or something like that. So while this may give a hope as to the unconstitutionality of the law, it's not the kind of a hope, it's not the kind of a victory that has the potential to be permanent. That's all I need to say about the expiration of the law itself. And now I'm going to ask Greg Vail to come on and talk to you about the vacancy and longevity increases.
Good morning, everyone, and thank you for coming to our seminar today. It's nice to see you all. It's been a while for some of my clients that are here today, so I really appreciate that you came to help us collectively sort through the chaos that's been sort of thrust upon us all. I wish I had better news than what I do, but here goes. How many people are familiar with the concept of the vacancy increase and the longevity increase for rent-stabilized apartments, right? That's a lot of us. Well, for the past 20 years or so, since the 1997 Rent Reform Act, the statutory codification of those increases has been something we've taken for granted. We get a rent-stabilized apartment back, we take our 20% increase. If the prior tenant that was in that apartment was there for more than 8 years, we took a per annum 0.6% increase on top of that. We took our individual apartment improvements on top of that, our rent guidelines board on top of that. And so the vacancy allowance permitted a very useful tool for landlords to increase their rent roll and move down that path toward high rent deregulation. Well, there are also some other benefits of the vacancy increase that, as a litigator in housing court for 28 years, I found useful in resolving cases. Oftentimes in holdover proceedings involving non-primary residents or licensee succession cases, a respondent would come in claiming that they have succession rights to an apartment. Well, we could sort of resolve those cases by saying to the would-be successor, fine, we'll compromise. We're going to give you a 20% vacancy lease. The would-be successor is happy because now he's got a rent-stabilized lease for the apartment he's claiming, and the landlord's happy too because he's got a nice rent increase and he's moving along that path toward high rent deregulation. Well, for those of you that have been hibernating or in denial since June 14th, those things that we've taken for granted for the past 20 years, those vacancy and longevity increases, gone with a stroke of a pen. Now, many of us sitting here had anticipated or maybe hoped that the legislature would take a look at those increases and say, okay, maybe 20% is too much. Let's reduce that to 15 or 10 or 5, something. That's not what they did. In case you don't know what they did, they took it away completely, both the vacancy and the longevity. They went further than that. What they did was they also codified a prohibition against any other governmental body from adopting, on their own accord, vacancy or longevity increases. And that's important because historically, probably from the late 1960s up until the 1997 Reform Act, the Rent Guidelines Board, which of course are the mayor's political appointees, the RGB took it upon themselves to afford landlords various vacancy increases and longevity increases, just the same way that they do now with the annual increases. They can no longer do that without the prior approval of our legislature. The chances of that happening, the prior approval part, not good. So where does that leave the landlord today when he gets back a vacant, stabilized apartment? Not in such great shape. Your options now are to take the annual RGB increase, which, as I think we found out yesterday, is 1.5% for a one-year lease and 2.5% for a two-year lease. You can also take the IAIs, the individual apartment improvements, which of course you're going to find out from this seminar have also been seriously limited and curtailed. You can also take any other lawful increases, but without having in effect the 20% vacancy increase, your ability to maximize your profits on that apartment have seriously been curtailed. Unfortunately, that's the state of the law now. One of the big questions that probably remains is if you executed a renewal lease 2 months ago with an effective date of, say, July 1st, containing that 20% increase, it may have to be redone. And that's something that we'll be looking at and answering questions on the index cards. And with that, I'm going to turn the program back over to Bob Goldstein because he's got more happy news for you about luxury deregulation. Mr. Goldstein.
Thanks, Greg. There's there's a very long-time employee in the office. Her name is Carmen, and she's been doing luxury decontrol since the luxury decontrol law passed in '93. And of course, the luxury decontrol is two parts. One is when the vacancy occurred and the legal rent was above the threshold at that time, which was $2,000, and then they moved it up. Then the apartment was automatically deregulated. Thereafter, they raised it to what the current level is, and then they changed the law in 2015 so that you needed to have one tenant in occupancy under rent stabilization with a legal rent above the threshold before you could get your deregulation. And then, of course, you had the high income filings that many of you have been involved in and that we've been involved in since the beginning, where the DHCR, in coordination with the New York State Department of Taxation, would determine if the tenant's income was above various levels over the different years when the legislature changed those levels from time to time. All of that is gone for the future. All of that is gone. Now, what we have been asked, and of course Carmen is not happy about that, as you're not happy about that. The real question that becomes the issue right now is, what about all the proceedings that are pending? And I think that for those proceedings, we have a very strong argument that the DHCR has to continue to process those proceedings that were timely filed up to 2018. Many of those filings go back to 2014, 15, 16, that the DHCR has just not made determinations yet for reasons known only to the DHCR, but I can assure you that those reasons have nothing to do with being helpful to landlords. So if you have a proceeding that was commenced in 2016 or 17, since the law itself required the DHCR to have finalized those filings in the year in which they were filed, you have a strong argument to say, well, wait a minute, the DHCR had an obligation to process our high income deregulation, and they didn't do it, so how could we be punished for that? So I just think you should keep in mind when you're deciding whether or not to continue to deal with the filings that predate 2019, so that you don't give away the possibility of a deregulation. Now, again, at some point in time, the DHCR will take a position on this. My expectation is the DHCR is going to take the most draconian position that they can, and that they're going to say that the deregulation by high income is gone. I think what will happen is we will speak to the clients where we have files pending. We will try to bring those clients together into some kind of a action so as to spread the potential cost, and then do something to get a clarification of the law, because as we know, the DHCR positions very often turn out not to be the case. Unfortunately, most of those interpretations that they made, such as with J51 or with 421G, we've seen that the courts have not gone in the direction that we would have liked, but we don't know what the future is. It may very well be, and we can be at least a little optimistic, very little, but that the courts will have seen how draconian these new laws have become as they're implemented, and maybe they will say, you know what, in this particular case, you have a constitutional right to have had your processing done in a timely fashion, and if that would have given you an order of deregulation, we're not going to punish you for the fact that the DHCR did not act. That pretty much concludes, and that's a pretty easy topic to deal with. If you have luxury deregulation filings, for high income, then we'll be talking to you about what to do about those from the past. As I said, I think the 219 filings are pretty much going to be dead. The 219 will probably be dead, because under the law, they have, as I said, until the end of the year in most cases. Now, if you had a high-income tenant who acknowledged that he was high income, right, and you filed in a timely fashion, the DHCR also had a time constraint to deregulate the apartment. In those cases, I would be very aggressive at holding the DHCR to the letter of the law, because I think that's probably as winnable a case as you're going to get, because the tenant acknowledged he was over income, he or she was over income, and the DHCR just didn't process it in a timely fashion. They have 30 days to process those kinds of applications. That said, we'll move on. And I believe Jeff Seiden, no? Right? Going to talk about preferential rents.
Good morning, everybody. I'm going to discuss preferential rents. Something that I think when we first heard that the rent laws were going to be revamped was something that the loud whispers were that preferential rents were going to be in danger. So this is maybe one of those things that didn't necessarily come as a huge surprise to everybody, that they were going to act as if this was a tool of the devil. So in the past, what we had was, really a preferential rent was a market rent, right? You had a legal rent, but in most cases you couldn't charge that legal rent because the market didn't dictate it. So in order to have a tenant, you gave a preferential rent with the appropriate riders under the law, stating it was only for this lease term only, and therefore you kept your legal rent if the market changed or as Mr. Vail said, you were on your path to deregulation at some point, okay? So what have they done now? They basically said, if you have a preferential rent now, and you have the same tenant, you cannot revoke that preferential rent under any circumstances. You now have to take your applicable RGB guideline increase off of that preferential rent for the duration of that person's tenancy, okay? So what does that sort of mean now? That means you take your 1.5% off of if the tenant's paying if the legal rent's $2,000 a month and the preferential rent's $1,000 a month, you're going to basically be taking your RGB guideline increases off of that $1,000 as you go beyond those years. The only real exception they carved out is if there's a government program that's receiving federal funds and things of that nature, where, if maybe the rent is dictated by someone's income, right? That's sort of what they're sort of saying, is that you're not bound by what that last that's part of a federal program. You can adjust the rent that isn't sort of comporting with the guideline increases, okay? As long as there are no warranty of habitability issues in the building, because again, all repairs must be done. The one question that has sort of come up, because they sort of dropped this on our lap on June 15th, is, well, what happens if I wanted to revoke a preferential rent for someone and I sent out that lease pursuant to the rent stabilization code a few months ago, and that lease takes effect on July 1st or August 1st or something like that? I believe at this point you would have to send them a new lease that comports with the current state of the law. I don't think you could say, well, I sent it to them on May 15th, even though their lease, even if they signed it on May 15th, I think because that lease does not go into effect until after the rent law came into effect, you would have to redo that lease. That's sort of the straightforward extent of what preferential rents are. I will turn it over back to Mr. Goldstein.
I want to just address one thing that Jeff said that you might consider, and that is, again, if you sent out the lease renewal, and the lease was signed, and you co-signed it and you sent it back, even though it's starting by July 1st, you may have the ability to go to the DHCR and say, this is what occurred. I'm either collecting it now or I'm not collecting it now, but I need you to tell me whether or not you believe that the law provides that I cannot get what was signed and delivered before the new law went into effect. Now, again, the DHCR has a procedure for administrative review of issues such as these where you don't know what the legal rent will be. Now, why would you do that? Well, number one, if you're going to collect a higher amount of rent, right, which of course is what you want to do, you don't want to be there a year or 2 years from now or 3 years from now with an overcharge complaint where you might be hit for treble damages. So by going to the DHR and saying, look, I don't know what the law is, my lawyers don't know what the law is, they can't be sure, we want you to tell us what the law is, I think the willfulness aspect of treble damages pretty much goes away. So keep in mind, if you have a fact pattern, such as the one that Jeff was talking about, you really ought to discuss it with one of us so that we can analyze which direction you want to go in terms of notifying the tenant, for example, if you decide to change the lease, to be on the conservative side, to put some kind of clause into that lease or the notice to the lease that says, look, we're doing this without prejudice to our rights, because let's say a year from now some judge says, well, by the way, in so-and-so's case, since the lease was signed and executed and everything, you had a property right, and they can't take that property right away from you. Okay? Now again, this is a gray area, but keep in mind that when in doubt about the legal rent, and it's going to happen a lot, the vehicle of the administrative application to the DHCR may be the only thing to save you or a successor in interest or someone who you want to sell the building to from being in serious question as to whether or not your rent roll is valid. So and then get hit for treble damages. So keep that in mind. And next up is David Cabrera to talk to us about rent overcharges.
So what I want to do this morning is talk to you a little bit about rent overcharges, but all of you should have in the package that was placed on the chair a summary of what the changes were. And I don't really want to go through I'm actually going to put my phone on timer and try to limit this to about 6 minutes. My goal is to tell you what the changes in the law were, what the old law was, here's what the new law says. I want to talk to you about, at the end, I want to tell you about, I've been getting a lot of questions, we all have over the past week and a half. I want to talk about probably the two most frequently asked questions that I've received on rent overcharges. And I also want to tell you that, look, we're going to tell you what the law says today, but we really won't know how it's going to be interpreted by the courts or by DHCR until, probably over the next few months, because basically every form that DHCR has will have to be revised. The rent stabilization rider. And we need to see how they're going to interpret these things, and as they start giving us and the general public direction, we'll give you updates. So for today's purposes, if I can go to the next slide, I really want to start with the statute of limitations, all right? So under the prior law, it was a 4-year look back, okay? And the only exception that really existed was for fraud, and that was based on a Court of Appeals decision. Now, this DHCR had, in 2014, they passed some code amendments, and they had identified 6 areas where they said there was an exception to this 4-year rule. So little by little, they were trying to, put little chinks into that 4-year statute of limitation armor and peel it away. Well, the legislature really kind of took care of that now, because what they've done is they've said that the statute of limitations is 6 years, which is consistent with what a look-back period is on a contract at 6 years, so a lease is a contract. But they, in the new law, they put in a word, and actually before I go into it, I want to tell you that the changes, especially in the rent overcharge section, were very, very specific and detailed. The more you read it, the more you sit there and say, whoa, this is not something that a group of legislators from throughout, the state sat there and said, here's something we have to change. They had input from tenants. They probably had input from the courts and lobbyists, because the changes and some of the things that they've put into this are very specific. And they've put in things that give them the opportunity, and when I say them, tenants or an attorney who's representing a tenant, whether you're before the court or in DHCR, it gives them an opportunity to really kind of raise issues. One of the exceptions is now where reasonably necessary, they can go beyond 6 years. I cannot stand here and tell you what reasonably necessary is, but it gives them an opening in the door and allows them to kind of go right through that. One of the other changes is that a complaint can be filed at any time, was inserted into the statute, okay? And that is significant because there's no more incentive for a tenant to file a rent overcharge when they move in, or they sit there and say, I've been living here for 5 years, I should probably file a rent overcharge. If they feel that there's an overcharge on day one, they might as well just sit there and wait. They could wait 10 years, probably not, but they could wait till the 6th year, file a complaint. They could probably allege something that happened beyond that 6-year period. The only thing is that they will only be able to recover damages for 6 years. But there's no incentive for them to really get that complaint in, because they can file a complaint at any time. If we can go to the next slide, which is record keeping. The prior law had a section in the rent stabilization law, there was a section that says owners have to keep records for 4 years. The code interpreted that as long as you had properly registered your building, you only have to keep it for 4 years. Well, the new law says you have to keep your records for 6 years. But what did they do? They put in an exception in there. So it now says, and other people will talk about MCIs and individual apartment improvements, but it now says that records with respect to improvements, whether it's an individual apartment, whether it was something that you did building-wide, like an MCI, must be kept. It doesn't say forever, but they say the owner has to keep it. And what did they insert in there? And if an owner did not keep it, it's basically your own peril, because now you can go back more than that 6-year period. So remember, so what I want you to remember today is evidence of individual apartment improvements, scan them, keep them electronically. It's important if you're going to sell your building. If you're buying a building, you want to make sure that they have records of anything, because it can come up even if it's more than 6 years ago. And more importantly, they've added useful life. And that's something new, and we need to kind of keep an eye out for what they're going to change. So I already failed at my 6 minutes. I'm going to move a little quick. Treble damages. The old law said if someone was going to get an award of treble damages, they could only get treble damages for 2 years before they filed their complaint. And then for the other, so if it was a 4-year look back, and let's say there was an overcharge for 4 years, 2 years was the overcharge plus interest. But you could not get interest and treble damages together. Okay, so 2 years was interest, 2 years treble damages. Now they said that treble damages can be imposed for a full 6 years. So that is certainly significant. The next slide. Registrations. In 1997, they inserted into a law a provision that if the only reason there was an overcharge was that there were missing registration, and this comes up if you buy a building. Sometimes you buy a building and a prior owner had not filed registrations for a period of time. In the past, if that was the only reason, and the penalty for not filing a registration is that the rent is frozen. So if the overcharge was caused by this missing registration, you could file it, and as long as the rent you were collecting was lawful, no overcharge, no liability. Under the new law, missing registrations is a basis for an overcharge and obviously treble damages. Once again, if you're buying a building, okay, and you see that there are years of missing registrations, in the past, we often said, well, there's a 4-year look back. As long as you're registered for the last 4 years, don't worry about it. If that comes up now, please contact us, especially if you're buying or selling, because this can have an impact on you. And a lot of times you don't see it because an apartment has been deregulated. Now you have to make sure that that apartment was lawfully deregulated. And safe harbor provision. This is an important one. There was a provision which was really a product of, I shouldn't have it under prior law. It was really in the rent stabilization code, where if you refunded an overcharge prior to, within your time to answer, or prior to a determination by the court or by DHCR, you realize that there was an old rent reduction and the rent hadn't been reduced. A hyper-technical, calculation error. If you refunded the money and gave the tenant interest, that case was over. They could not impose, any overcharge liability. Under the new law, even if you refund the money and you say, you know what, we were wrong, here it is, you can still be liable for treble damages. So they can continue to process those cases. And the last thing I want to cover is, I thought I was up to the last lead, attorney's fees and costs. Under the prior law, attorney fees was discretionary. If you had a case before DHCR, most tenants do not have an attorney. But even if they did and they asked for it, DHCR would always say, look, unless the owner had really disobeyed maybe a directive from DHCR and it was really willful, they would not impose treble damages. Under the new law, they've used the word shall. Shall is mandatory. So this is something that we have to keep an eye out for, how they're going to do this, how they're going to determine someone's entitled to it. But it's not just attorney fees, it's costs. They can award costs. And obviously this rule applies in court. So the most frequently asked question, I would say, over the last week and a half is, do these changes apply to a pending case? And here's where I tie back what I said in the beginning. These changes were very specific. Bob Goldstein talked about the effective date, June 14th. In the overcharge section, they actually put in language that says, the determination of the lawful rent, the determination of an overcharge is based upon the law in effect at the time of the determination. Which means that if someone filed a complaint before the law changed, and for whatever reason that case has been pending at DHCR, they can now apply this new law because they are applying the law in effect at the time of the determination, not the law in effect at the time that the complaint was filed. And this is like one of the only sections that has this language in there. So we need to kind of keep an eye on that. So I would say that more than likely, we need to see what DHCR is going to do, or the courts, but more than likely it will apply. And the other question is, how do I avoid treble damages? If it's now 6 years, if you can't refund the money. And what we would say is, look, there is still a presumption of willfulness. However, it's more important than ever when you receive an overcharge complaint that you talk to us and you put in evidence and you put in as much as you can. You challenge that willfulness standard. This was not something that willful. This is something that occurred because it happened under a prior owner. Once we came in, we corrected it. So you need to really start looking and identifying arguments and preserve our right, possibly on appeal, to try to make an argument for the, elimination or so that they don't impose treble damages. With that, I'm going to say thank you, and I'll be here for questions. And I'm not sure who is next.
Just a brief comment about some of David's remarks. The issue of whether or not you applied a guideline properly, right? That's pretty cut and dry. The issue of whether or not the increase which had been granted for vacancy, it's pretty cut and dry. The real problem is going to be them applying the standards in presently pending cases to IAIs, which the scrutiny by the individual owners has not necessarily been as careful as it might have been in retrospect. So that's really the place where, if they're going to get you on an overcharge now, and you have to produce the filings, the proof of what actually was paid and the categories of what you paid for in those apartments, right? That's where, if they find that this was not proper, that you were not entitled to that element of the work that was done in the apartment, right? But because you never had to file it, you never had to get it approved. The only time you ever had to get it approved was when there was a filing of an overcharge complaint, or you went to court and the tenants challenged that. So you need, in order to be careful now, you need to go back on every single apartment, right, where you did IAIs and say, here's the hypothetical. A new tenant moves in, and at any time he can file a complaint, and the DHCR reviews it and says, come up with your records, right? And somehow or other they disallow 20% of what you did as an IAI. By doing that, they then put you into an overcharge. And then by doing that, they put you into next the question of treble damages. And then the question of 6 years. Okay, so this is something that, really hasn't been focused on yet, but I would suggest that every apartment needs to be reviewed. Every apartment needs to be reviewed now, right? If you deregulate an apartment, you need to know that the IAIs are going to stand up to have brought you over the threshold. Okay, it's not like an MCI where you get an order from the DHCR and you apply it. It's something that you did yourself. You self-certified that, and if you didn't have David or someone like David review every element of what you put into that IAI addition, you have a potential overcharge, you have a potential willful overcharge, and you have a potential 6-year overcharge. Now, the question of the language of the law, which makes it apply to currently pending cases, right, is another chaotic exercise by them in an effort to put you in a position where you really will have very little options sometimes but to try to settle. I mean, there's litigation that is going on for years where they basically are saying, well, let's do over everything. And this is frightening. Whether it's constitutional or not is something that is going to have to be litigated, because in the opinion of the United States Supreme Court in a California case, they talked about the fact that changing statute of limitations and making it applicable, making it retroactive, right, or passing laws and making them retroactive is potentially in violation of the United States Constitution. Anyway, so again, another minefield to try to get through. And now the next speaker will be on stabilization coverage. Steve? Yes. Steve Schulman? Thank you.
I'm going to be very short. That's about how tall I am. This is very simple. It's a little anecdotal, I think, because there really isn't a lot to say on the act itself, because you can read, and on page 3 of your memo, it has the same information if you'd like to follow along that way. But what I think is important is that when an act is written, as it was here, there's a legislative finding. And I'll be very, very brief on that. But the short title of this act that was passed on the 14th is known as the Statewide Tenant Protection Act of 2019. In order for them to be consistent, they had to eliminate a portion of the legislative finding, which I'm going to read because I think it's interesting. The legislative finding was in the original act: the legislature hereby finds and declares that a serious public emergency continues to exist in the housing of a considerable number of persons in the state of New York, and this is what it used to say, and it was eliminated, which emergency was at the inception created by war, the effects of war, and other hostilities. So, how far back do we go at the inception of rent regulation? We go back to when there was a war, when there were hostilities. Now, I don't know if that's the Vietnam War, the Korea War, the Second World War, but obviously, since there are no wars now, they had to eliminate that, but they didn't substitute it. So it's silent. So this goes back to what Mr. Goldstein said about what is the basis for which they've determined that there is a emergency that's continuing now that requires not only this to continue, but to continue permanently. I think it's important because you may see this later on if a lawsuit is filed. Nevertheless, this act now previously had only been applicable to New York City, obviously, and to 3 boroughs. 3 counties, the Nassau County, Rockland County, and Westchester County, if they chose to opt in. They've now expanded that to every county in the state of New York. And there appears to be no time limitation that county could decide that they have a housing emergency. And they are going to adopt this rent regulation, and they are going to assemble a rent guidelines board, and the law has a whole bunch of provisions on how that's done. So for those people, and I have some clients who have called me about property that they own elsewhere, I suppose it's all fair game in the state of New York. So if you thought that perhaps buying something in an outside county in upstate New York, western New York, may protect you, it may not. Nevertheless, that's the legislative. The other thing I wanted to talk briefly about was the next item, which also is on page 3, is fuel cost adjustments and MBRs. Those that have rent-controlled tenants are aware that year to year when you file your application for your MBRs, as long as the formula coincides or is not above your maximum collectible rent, and as long as you remove violations and other requirements, you have generally been getting a 7.5% increase. They decided to change that, and what they've decided to do is to say that you will be eligible to collect no more than 7.5% or the average of a 1-year renewal lease for a rent-stabilized tenant for the past 5 years, whichever is less. Now that's obvious. I don't think they have to write less because we all know that when there's a choice, you're going to get less. But that's important to understand so that it may not affect many because I don't know how many rent-controlled tenants are left in the city. It's dwindled with, over time. But anyway, it's important to understand that you should not just expect that you're going to get this 7.5% increase. The other question raised is 5 years, whether or not this goes back. So for example, if you're filing now, and again, I don't have an answer to this question, but it may be a question that comes to some of your minds. When do they count 5 years? Is it going to continue in effect in the next 5 years? Are they going to count back to the last 5 years? Again, you're going back to a period of time prior to the commencement of this act, and they're going to use rent guidelines increases from the past. So it's something to think about. Thank you. Back to Bob.
Yeah, I think just to emphasize what Stephen said about the, especially if you have properties even in Nassau County, where there are, for example, the town of Hempstead and the town of Oyster Bay have never opted for rent regulation. I could see the pressure being placed on those town councils to declare the emergency, because of the pressure that's going to be put on them by the very, very active and strong tenant lobbyists now who have been so successful. So if you have properties there, be mindful that you might want to somehow try to get involved politically, so as both of those towns are controlled by the Republicans. Hopefully those towns will continue to be controlled by the Republicans, but I know a lot of clients have properties in the town of Hempstead and Oyster Bay, not to even mention Suffolk County, which has never been included, which is also subject to the same kind of pressure. So again, that process over the years has mirrored New York City in those jurisdictions where the Democrats have controlled the process by which the Rent Guidelines Board is constituted. And just to bring us back to the history here a little bit, many of the rent guidelines that had originally been passed, for example, in Westchester County and in Nassau County, had given significant vacancy factors before the '97 law was passed, and they also had given the ability to raise the rents up to the rents of perhaps the highest rent in the building. A lot of different permeations of that, and the legislation has now closed that off completely. So with that said about the coverage outside of New York, which doesn't affect a lot of people, but may affect the thought process of people who are looking to invest outside of New York City now, be mindful of the fact that that's a reality. And now we have, let's see, Paul Gruber. I'm going to talk about owner's own use, or the lack thereof.
Good morning. Thank you for all coming. I'm going to talk about the owner's own use provisions of the rent stabilization law and the rent control law. Okay. Can you hear me? No? Okay. Yeah, let's do it that way. I'm going to talk about the owner's own use provisions of the rent control and the rent stabilization law. They have significantly changed. One element that hasn't changed is that only an individual owner, as opposed to an LLC or a corporation or an LLP, may maintain owner's own use proceeding. The idea behind this was that if you own a building and you're a small owner and you worked hard and you bought yourself a small building, you should be able to live there with your family. That was the idea behind it originally. In the past, under the rent stabilization law, there was no limit on the number of units that an owner could recover for his personal use or the member of the family. Only one owner could do that, but if it was a husband and wife who owned the building, that really didn't matter too much. That was a situation where you might have a dispute between two tenants in common who are not related, but that's a little beyond what we're going to talk about today. Under the rent stabilization law, as long as you had a good faith purpose to use that intent to use that apartment as your primary residence in the city of New York, well then you could recover. The rent control law had this standard of immediate and compelling necessity. We'll get into what that means or doesn't mean in a couple of moments, because that's become relevant again. Now, the good news on the new statutes is that the regulatory requirements for the rent control law, the rent stabilization law, and for the outer counties, the Emergency Tenant Protection Act, are all the same. The bad news is they are considerably more draconian. A single owner can
can recover use for himself or a member of his immediate family for use in occupancy as a primary residence. The Rent Stabilization Code used to have the language in the city of New York. That's been eliminated. The idea now here is that if the owner or his family wants to recover that apartment, they have to meet the same primary residence tests that tenants have to meet in order to maintain their protection under the law. In the past, the owners could recover more than one unit. Now you're limited to one on this ground only. Does that mean that if you've gotten an apartment back based upon an owner's own use theory and litigated that issue before, you can't get another apartment? Well, that's not clear from the law yet. That's something that some lucky owner will get to litigate one day, I think. And does this prohibit you from using this ground when, for some other reason, you got an apartment back and you put a member of your family in there or moved in yourself? Well, probably not, but we're living in different times now, so this may be a question that has to be addressed at some point. Now, we had mentioned immediate and compelling necessity. You didn't have to show that under the rent stabilization law. You had to show it under the rent control law and the ETPA. Now that standard applies for an owner to get back an apartment for his own use or family use. Immediate and compelling necessity. What does that mean? Very good question. There were a lot of cases in the 50s that discussed this issue because, as amazing as this may sound to some of you, if you had a one or two family house back in the 1950s and you wanted to get back a unit for your own use, you had to show immediate and compelling necessity because back then some of those buildings were covered by rent control. One thing that we could glean from the old case is that it's something more than the mere convenience. What immediate and compelling necessity means in 2019, again, is something that we're going to have to find out. And there's a second restriction on recovery. This was in the rent control law and the ETPA, but not in the rent stabilization law, but it's in all three statutes now, and it's a little bit more draconian than it used to be. You cannot use this ground to recover an apartment where a member of the household lawfully occupying the unit is 62 years of age or older. In rent control, that had, in the past, pretty much eliminated your ability to get an apartment back on this ground. Owners, if they wanted the apartment back for their own family use, had to figure out a different way. Another reason you won't be able to use this if the person has been a tenant in a housing accommodation in the building, not the apartment, the building, for 15 years or more. Under the prior versions of the rent control law and the ETPA, that was 20 years. The legislature reduced that by 5 years. And also, if the tenant has certain medical or physical conditions that are expected to be permanent and prevent the tenant from engaging in substantial gainful employment, well then, you can't use this ground either. The statute also includes another kicker. If the tenant is required to surrender an apartment on this ground, owner's own use, he can sue the landlord if it turns out that the landlord made a fraudulent statement regarding the proposed unit's use of the apartment. For example, if the landlord brings an owner's own use case because his daughter wants to use needs an apartment, let's say, she just left a messy marital situation or is coming back from school or something like that. And then it turns out that the owner, instead of putting his daughter in there, put in another family member. Or maybe he just rented out the unit to somebody else, or maybe he turned it into his workshop. That tenant can sue the landlord, his former landlord, for declaratory judgment, damages, legal fees, and injunctive relief. Does that mean that a court could order the tenant back into that apartment? I don't know the answer to that. But this is a bit broader than the cause of action that used to exist under the rent control law, which which are strictly limited when that tenant can bring that cause of action. The statute of limitations from fraud is 6 years or 2 years from the discovery of the fraud. I don't think you're going to see a lot of this, but again, it's out there. Couple of little other comments. If you're looking to bring an owner's own use proceeding, if you're a rent-stabilized landlord or an ETPA landlord, you go straight to the courts. You serve a notice of non-renewal of the lease, and then you bring a court proceeding. Rent control requires obtaining a certificate of eviction from DHCR. Now, a lot of this owner's own use stuff affects small owners, people who bought a house for their families, people who bought a house as an investment and decided that they want to have their family in the building because, you want your family near you sometimes. So exactly why did the legislature choose to beat up on the little guy here? Well, I think the answer could lie in a 10-year-old Court of Appeals case which talks about the extremes. We're all in the real property business, management business, litigation business, and we know that most cases are normal, but there are a few cases out there with outrageous facts and outrageous issues, the extremes, and we also know that in pretty much all areas of the law, the general public only sees those extremes. That's the stuff that the newspapers report, that's the stuff that gets talked about on the internet, and that's the stuff that tenant activists will focus upon if it has to do with landlord and tenant. There was a case from the Court of Appeals, Pulse versus Economakis. It was around 2008 or so. Mr. Economakis and his wife owned a 15-unit building. I think it was in Greenwich Village. There were 6 stabilized tenants. And the Economakis family wanted to turn this 15-unit building into a single-family residence. This created outrage among the tenants in the building who went to sue the owner for a declaration that, under the rent laws, you can't do this. The Court of Appeals said, well, yes, you can. And everything that the Court of Appeals said that you can do, now under the current law, well, you can't do as much of that anymore. So this is a situation where, in my opinion, where you had one extreme situation which now dictates the rule for everybody else. Whether that's fair or right or not, I'll leave that for you to judge. Thank you very much.
Thank you, Paul. Can everybody hear me in the back? Can anybody hear me in the back? Okay. Just a couple of comments that I have, and I have a little different view of this than Paul had stated, and that is that somehow or other they had put this into the law so as to give something to the landlords that was nice or good or whatever. The truth of the matter is that this has been in the law because there's a great concern that any rent law that doesn't provide for an owner's own use provision in some way could not be constitutional, would be in fact a taking of that property. And there was a client that we had by the name of Mr. Harmon who tried and was successful in at least getting from one federal court level to another, but he ultimately lost. I won't go into the reasons why. It wasn't a good case. But I think that ultimately the owner's own use issue is going to be an issue where the courts could very well rule that the absence of a reasonable and doable owner's own use law will be fatal to the law. But again, as I said before, what they could do in that kind of a challenge is they just change the law back to something else. Now, again, the new law provides for one unit in a building. So in theory, if you had a building that had only studio apartments, for example, a six unit building or an 8-unit building with mostly studios, maybe a 1-bedroom, you're kind of stuck in the sense that they're saying you can only get one of those units, which is patently absurd. But that's what the law says. Now, you might consider combining 2 units lawfully, right? And in anticipation of at some point in time going for an owner's own use case. You might consider at some point in time combining 3 units, you know, and then going to get that what's now 1 unit on your certificate of occupancy. Those are my little comments about Paul's presentation, and now we're going to get to Carlos and the not-for-profits.
All right. I'm kind of an antsy guy. I'm in court all the time. So I invite you all right now, 7-inning stretch. Stand up if you'd like to. Wiggle a little bit if you need to. I'm going to be short. Go ahead. It's okay. I'll stretch with you. All right. Are we good?
There's no way you can be short.
All right. Here we go. This section is for scatter sites. All right. It's a non-for-profit corporation for apartments of use by vulnerable individuals or individuals with disabilities who are or were homeless or at risk of homelessness or rent stabilized. That's going to take an effect when the lease ends in the next subsequent lease. The major thing that we should be paying attention to here are the affiliated subtenants are authorized to use the apartments now as tenants. So please pay special attention to all of your if you are a non-for-profit, if you're renting to a non-for-profit, you have a new scenario now where the subtenants are now tenants. And that will open up a whole host of issues in the future, and I invite you to talk to me or anybody in the panel about those issues. Good luck, and we'll see you all later.
Carlos, you had a great idea. Let's take a 5-minute break.
I'm here to speak about individual apartment improvements and MCIs, and those of us who work in the area of rent regulation and deal with these topics didn't quite realize that it helps to be good at math, even though you're a lawyer. So the IAIs have obviously been under scrutiny for some time now. You have TPU IAI audits. You have the requirement to register individual apartment improvement increases on the annual rent registration forms now. As Bob indicated, they've been a big subject in overcharge complaints. But they are now, the ability to collect IAI increases has become severely restricted under the law amendments. And some of the language raises questions. Obviously, as other people have mentioned, there will have to be rent stabilization code amendments or policy statements that will explain things a little more. One of the things that may raise questions is that what qualifies as an IAI now is subject to a finding that it's a substantial modification or a reasonable and verifiable modification. So those words just raise questions about what do they mean. And until and unless case law may define that more, there probably will be a lot of questions raised in these cases. I actually had to read several times the part that said $15,000 for not more than 3 IAIs in 15 years. I thought that meant 3 times you could get $15,000. That does not mean that. The word aggregate is in the statute, which means in a 15-year period, you can take a total of $15,000 for IAIs, and the percentage increase is extremely reduced. I had to read those numbers a few times, 1/168th. So wondering what that meant, and having to do math now as part of my job, I did a little calculation. $15,000 means when you were collecting 1/40th or 1/60th, you got $375 or $250. Now you get $89 or $83 for those increases. And I think that IAIs and the MCIs are an area where, as we've discussed, there is a federal lawsuit that's going to be commenced to challenge the amendments to the law. And, if the question is what is being done, does it constitute a taking of property or is it confiscatory in some way? Looking at how the reduction in what you can collect for IAIs and MCIs in your specific cases, figuring those things out and compiling data and consulting with any of the real estate industry organizations you may belong to may be helpful in pursuing cases about that. Otherwise, on the IAIs, one thing that the cleanup bill did, because we were immediately getting questions about, I just signed a vacancy lease mid-June for a period starting July 1st, and what does that mean about my IAIs? The cleanup bill said that the change in what you can charge for the IAIs is effective on IAIs that you performed after June 14th. Now, how that affects leases that are entered into, maybe executed before June 15th and taking effect after June 15th. If you still have questions about any of that as you're calculating the rent increases, you may want to talk to one of us in the office. A couple of the things that specifically changed: you now have to have a licensed contractor to do your IAIs. You know, you used to be able to hire the super to do it. There were cases that said, you know, it had to be clear that it wasn't the super as part of his duties, his regular duties, doing the IAIs. You had to pay them separately for that. Now you can't do that anymore. They say you need a licensed contractor. If the owner or property manager had a relationship with the contractor, you know, it was a family relationship, or there were people who were part of one corporation and also the other, that in the past would increase the scrutiny of IAIs in the context of an overcharge case. Now, you simply cannot do it. The law says that there cannot be a common interest between the contractor and the owner. The new law also says that to get an IA increase, you have to resolve hazardous violations. What exactly that means, I'm not sure. It sounds like it means you have to clear them or you're not going to get an IAI increase, but it's a little unclear what it means. Okay, on MCIs, similarly, you know, I don't go back as far as Bob to the days of the ETPA, but I started working in this field. Well, I go back to at least 1984. My first job out of law school was working at RSA, and I started the week that the Omnibus Housing Act went into effect in 1984. So I had to learn all about the 4-year rule. I had to learn about rent registrations. I had to learn that, you know, there was a huge media campaign for millions of people to file complaints by March 31st of 1984. So I have seen, you know, how things have progressed. But my point was that since I have worked in this field since 1984, every year tenant advocates have proposed doing away with MCI increases or making them temporary, and it never went anywhere until now. And you know, you've seen our exhibit to the memo. There are questions raised by the changes in the definitions. You know, the MCI must be essential for the preservation or energy efficiency or functionality or infrastructure of the entire building. That, just the language of that will probably raise questions. There will probably be questions raised about just calculations. You know, if you got an MCI approved between June of 2012 and June of 2019, you were collecting pursuant to a 6% cap, but now starting in September, you have to apply a 2% cap. More math nightmare. Retroactive MCIs have been eliminated, which for you know, people at my end is a good thing. I realize it's not a good thing for anybody else who's collecting the increases. And there are just other changes that it will remain to be seen how they are interpreted by DHCR. Forms will change. One thing, while the law was clearly said that in the case of rent overcharges, the changes in the law made as of June 14th are applied to pending cases. It doesn't say that about MCIs, and I'm sure, you know, I don't know how many pending MCI applications there were on June 14th, but except for these provisions about applying the 2% cap and giving some dates about that, it doesn't say, but I would presume, as David mentioned about something else, that they will probably apply the current law to any pending MCI applications. Thank you.
Thank you, Eileen. Can you hear me in the back? Okay. I have a couple of comments. First and foremost, just imagine right now it's April 14th, and you're sitting with your accountant, and your accountant says, well, what was your charitable contribution last year? And you say, oh, I'm not sure. He says, well, in your tax bracket, if you say $9,000 instead of $5,000, you're going to save $2,000. And unfortunately, as we're sitting here today, the IAI situation, which was always basically an honor system, could really come back and hurt you. That's why it's so important to analyze every rent that was ever affected by an IAI now. Because make no mistake about it, like Eileen said, in 1984, the tenant lobby and everyone else went crazy getting people to file complaints. And you can be sure that there's going to be literally hundreds, maybe thousands of overcharge complaints filed going back 6 years, which are going to challenge IAIs. And if your IAIs don't stand up, not only will it affect those rent-regulated tenants that are still rent-regulated, but it also could affect those ones that you had thought were deregulated. So again, we cannot caution you enough that a total review of every apartment that you manage or that you own must be made. The other thing I wanted to comment was, in buildings that have a significant number of deregulated apartments, they've now said that if 35% of the building is, less than 35% is rent-regulated tenants, then you don't get any MCIs. So if you're sitting there and you file for an MCI, right, and you've got 37% of your building that is, regulated, and you just, right, you're so close, you'll be okay. But if you've got 34%, well, you know what? Don't waste your time, because those 34% are not going to get you the increases, and the rest are deregulated. So, obviously, that's a consideration that has to be viewed as you're filing the application. And the next question is whether or not anything changes while the application is pending to determine whether or not the apartment is regulated or not. Now, this is really relevant in co-ops, where you've got a co-op conversion where you've sold, 65% of the units, and now you have 35% which are regulated, and one of your tenants, moves out, dies, or whatever, and by operation of law, thank God they've continued that law. Not with God, but that's, but at the end of the day, that deregulation occurred, and you've now gotten less than the 35%. So if you're that close, you could put in jeopardy your whole MCI application, because it's unclear as to whether or not you're going to qualify. Anyway, just a couple little comments that I thought were relevant. We have the big topic now. Okay, so we have numerous people who are going to speak about what we've come to call the M for murder section of the law for landlord and tenant practitioners as well as the managing agents, because a lot of this deals with changes in the procedural law of landlord and tenant in court. Now, the only thing I can say on a personal level, that I was there in 1997, and RSA and CHIP had asked me to write legislation to be submitted to the state Senate in the hope that we'd get some progress procedurally in what was going on down in court. So I drafted some things on rent deposits. I drafted the things on statute of limitations. And, you know, to the extent that they were followed by the courts, sometimes yes, sometimes no. So when I was reading this, it was almost as if one of my tenant lawyer friends, okay, was up there actually going, well, you know, Bob had written this, so we better change it. Okay, and that's really what they did. Whatever we did in 1997, they pretty much eviscerated. So now I'll turn this over to Todd, Lester, Carla, I think you're involved in that, and David Rosenbaum as well. So you guys decide how you're going to handle it, okay?
So I am the first speaker on the murder section of the law. And it's interesting because yesterday I met with a client for 2.5 hours to discuss the new law. And at the end of the presentation, I asked, do any of you have a question? And one of the agents shyly raised her hand and she said, why do they hate landlords so much? Well, here we go. The M section. I'm going to discuss the changes to the real property law, the RPL. And the first change that I want to discuss with you is the one that deals with retaliatory eviction. That is a defense that attaches to any case that is started by a landlord against a tenant who has filed a complaint with any administrative agency for pretty much any reason whatsoever. So you sue a tenant, and it happens to be that that tenant has filed an HP action for repairs against the landlord, and the old law used to say, you know, within 6 months from the date you started the lawsuit. Well, now they extended that to 1 year. So if one of your tenants has filed a complaint against you or made a complaint for conditions in the apartment and you happen to sue that tenant, there is an implied or a presumption that you're doing that to retaliate against the tenant having filed a complaint. That's why it's called retaliatory eviction. So now it used to be 6 months, now it's 12 months. Now, one of the grounds for retaliatory eviction is warranty of habitability. The tenant wants repairs, and it happens to be that the lease expired and you want to start a holdover for lease expiration. Guess what? That tenant may have or will have the right to interpose a retaliatory eviction defense. Now, these are presumptions, which means that they are rebuttable presumptions. We can fight that in court, but you should know that you got to be careful when you start a case. These complaints also include complaints about the Housing Maintenance Code and the Multiple Dwelling Law, and it is called the good faith actions of the tenant. The other thing that we need to understand is that presumption will also attach to an agent of the landlord. And it is interesting because under the old law there was an exception, and that is if you started a case for non-payment of rent or you started a case for breach of lease. Well, those exceptions are out of the law. So even if the tenant owes you rent and you in good faith are starting a lawsuit for non-payment of rent, that presumption will be present when you start that case. And again, can we fight it? Of course we can. But you should know that it's out there. RPL 226C. This is the notice of rent increase or non-renewal of residential tenancy. Now, this kicks in 120 days after June 14. However, you should know that if you're going to offer the tenant a lease renewal with a 5% or more rent increase, you need to give the tenant notice of that increase and of that renewal. Here we go. If the lease that you're renewing is in existence for a year, or the tenant has been in occupancy for a year, you have to give a 30-day notice. If the tenant has been in occupancy for 2 years, or the lease is for a 2-year term, you have to give a 60-day notice. And the third is if the lease is 2 years or more, that's a 90-day notice. That's if you're going to offer a lease for a rent increase that offers a rent increase of 5% or more. And the same 30, 60, 90 days notice applies to deregulated tenants when you're going to tell them you're not going to renew the lease. It used to be that a deregulated lease expired, you will go straight to petition, straight to court. No previous notice was necessary. Now you have to give that tenant notice. 30, 60, 90 days. Also, that section deals with mitigation of damages. Tenant breaks the lease in the middle of the lease and leaves the apartment. Well, you know that you need to mitigate damages, and that means that you have to aggressively market your apartment. Now, the change is this, that you cannot say that you haven't been able to rent the apartment if you're offering this apartment at a rental that is much higher than what you were, that the prior tenant or the tenant that broke the lease was paying. In fact, the law says that you not only have to offer the apartment immediately in order to mitigate damages, however, at the fair market value or at the rate agreed to during the term of the tenancy that just was broken, whichever is lower. So you cannot now say, well, I haven't been able to rent the apartment because I haven't found a tenant that pays $3,500 for this apartment that was rented for $2,000 before. Okay? It has to be a market value or at the rental being paid under the previous tenancy, whichever is lower. And the moment you sign that lease, the prior tenancy is terminated. Steve Schulman will deal with 227F. Now, 232A, notice to terminate monthly tenancy. We spoke about that. Deregulated apartments, 30, 60, 90 days. And that is effective 120 days after June 14. Now, here's the big question that I have been asked over and over and over. When you're going to start a non-payment, the law now requires that you advise or you let the non-paying tenant know that he hasn't paid the rent. Okay? Maybe the tenant didn't know that he didn't pay the rent. But the law now requires that you send a letter by certified mail on the 5th or after date after the rent was due. If the rent was due on the 1st of the month, on the 6th of the month, you are to send out a letter indicating to the tenant that the tenant has not paid the rent. Okay? Now, this letter has to be mailed by certified mail. Must be done. Why? Because if you then decide to start a non-payment action against this tenant, you must understand that it will be an affirmative defense to your action that you did not provide that 5-day notice to the tenant. Now, that notice does not have to say, it's not a demand. It's not a demand. If you don't pay, I'm going to sue you. No. It's just letting the tenant know you didn't pay the rent, just in case the tenant missed writing the check for that month. The other thing is, the other question I've been asked is, what happens if you do that? Does the requirement attach to every month? Right? The tenant on July 1st owes the rent. Now on July 6th, you send out that letter. What if you know that that tenant is a frequent flyer, someone that you're constantly suing? Are you going to send that letter immediately, or are you going to wait for August to come in, and then send one notice for 2 months. Can you do that? We don't know. We don't know. Surprise! You're going to go to court, and the really wise young legal aid attorneys who are now just salivating, waiting in the hallways, waiting for them to be assigned a case. By the way, they have now motions to dismiss on automatic pilot. The moment they get involved, it's the same motion. Same motion. Doesn't matter who the landlord is, doesn't matter who the tenant. When those firms get involved, they do the same motion to dismiss. Anyway, so now you get your motion to dismiss, and they are alleging, well, no notice was sent on July 6th. The only thing the landlord did was send one notice in August for July and August, which the law says it doesn't say whether you can do it or not. It just says if the tenant owes, you send them that notice 5 days after the payment was due. So we're going to find out when we get to court, we're going to find out if you have to do one every month, or you can combine them so that it could be a little more economic for you to run your buildings. I spoke to a client yesterday. They have 6,000 units. Usually 3,000 tenants pay the rent between the 15th and the 30th of the month. If they have to do one notice per month, that's $20,000 just in mailing alone. Just so that you know. So we don't know exactly if it's one per month or we can combine them. My suggestion, belt and suspenders. You see, the law is, the name of the law is Housing Stability and Tenant Protection Act. It is not Landlord Protection Act. So you need to assume the worst. Understood? 5 days after the rent was due, you have to send a letter. We don't know if you can combine them. The safe bet is we're going to find out when we start the case. The safest thing you could do is do it after every month. Every month when the tenant owes rent. Then I was also asked, what if you're already in court? You sued for July and August. It's September 5th. Your case is on for the first time. Do you have to serve a notice for September and October, and as long as the case is pending? You're already in court. And the answer is, we don't know. Odds are you're going to have to. Questions afterwards, please. Let me see what else. Now, when you start a non-payment, I knew it. This was going to be it. Okay, when you start a non-payment and the tenant does not appear, what do you have to do? You have to do a non-military investigation. You know that, right? Now, let's assume you can't find the tenant. And you go ahead and you make a motion to dispense with a military affidavit. You all know that. We do it a lot. Here's the thing. You finally won the case. You finally got your warrant. And you finally got your apartment back. And now you turn this over to your collection attorneys. Guess what? Under the new statute, RPL 234 says that a landlord may not recover attorney's fees upon a default judgment. So you have now invested $3,000, $4,000, $5,000 in this default, and once you try to collect, those legal fees are not recoverable because you obtained the judgment on default. Let me see what else. Receipts. When the tenant requests a receipt for payment in cash or any other form of payment other than a personal check, the tenant comes to you and says, I need a receipt. You must provide that receipt. And the receipt must be very specific. It must have the date, the amount of the payment, the identity of the premises, and the period for which it was paid. And the signature and title of the person receiving the rent. It used to be that you say, okay, this tenant owes 6 months rent. I'm going to apply it to the oldest debt. No, you apply it to whatever it says on the memo portion of the check. If it says, no, this is for June's rent, that's how you apply it. And the receipt must indicate so. And if the tenant requests a receipt, that tenant now has put you in the obligation that every time you receive a payment, you must give a receipt. They ask once, it attaches as long as that tenant is your tenant. At this point, I would normally ask any questions, and I won't do that. What else? You also, if the tenant pays the landlord or an agent of the landlord authorized to receive the rent personally, the receipt of such rent shall be issued immediately. So no, I'll send it by mail. No. Immediately. However, if the payment is transmitted indirectly, then the tenant shall be provided with a written receipt within 15 days of payment. Understood? That's my presentation. We'll have questions at the end. And I know you all have questions. Thank you.
I just have one comment about Lester's presentation, which I thoroughly enjoyed, Lester, by the way. On the issue of mitigation of damages, because this is going to come up when people break leases. Remember, everything Lester talked about on the notice provisions and things like that have to do with deregulated apartments. Deregulated apartments, because under the stabilization, those are covered by the stabilization code. But on mitigation of damages, let's assume for argument's sake that the tenant moves out 3 months before the lease ends, or 4 months before the lease ends. The statute doesn't tell you what to do as far as the lesser of. So let's assume the tenant had a 2-year lease, and the market has changed, and the market has gone up. It's the lesser of the fair market rent or the previous rent. But if somebody's moving in now, why in the world would you want to mitigate the damages in the future by giving this tenant a 1 or a 2-year lease and saying, well, I'm going to give it to you at the old rent? So the question becomes, how do you formulate a lease? Now, in the rent stabilized world, it's really not going to be that big an issue because the guidelines are so puny that it's not going to make a big difference, and you're regulated as to what you can get. The issue then becomes, in a deregulated universe, can you give a bifurcated lease? In other words, you offer the new tenant for the next 2 months or 3 months the old rent that the tenant who had moved out wrongfully or prematurely was paying, and then for the balance. And the answer to that is I think you can. I think it shows good faith in trying to mitigate the damages rather than just, not really marketing that apartment until the end of the lease. So keep that in mind, that you can't avoid giving that lease for a couple of months at the old rate and then raising the rent higher when that old lease would expire. And I think you'll be okay with the mitigation question. Todd?
Continuing with the entertainment portion of the show, let's go to housing court. I just had a thought. When I was reading this, I said to myself, if I sat in a room by myself for a month deciding how could I screw landlords, I couldn't come up with anything better than this. This is absolutely amazing. So they have made changes, and every one of the changes was out to hurt you. For example, on RPAPL 702, what is rent? What can you sue for? There was a time when you could sue for late fees, There was a time you could sue for legal fees. There was a time you could sue for electric fees. You can't. You can't sue for the gym fees. You can't sue for the storage fees, not in a non-payment proceeding in housing court. At this point, according to the statute, you can sue for rent. Just rent. Just rent. Now, I believe, and I'm kind of hoping, against hope, that much of the industry will decide to fight back this. And how would you fight back this? You would bring plenary actions for the legal fees, for the late fees, for the storage fees. Now you might say, but is it really worth it? In some regards it is. In many regards it's not. But just think of our industry taking all those cases and piling it onto the court. Killing those judges. I didn't mean that. I didn't mean that.
You didn't mean it.
I didn't mean it. Yeah, okay.
Would you please erase that?
Don't take it that way, okay? But it would be an overwhelming amount of work for those persons who have not been very helpful to us, even before the law. Let's face it. We're talking about the time, and we'll go into the time that it takes to bring a case. What was it like before the law? It was not nirvana, was it? If you went in June 1st, if you were going out to trial and say, I am ready for trial, would you go to trial? Could you possibly go to trial? No. Maybe sometime in September, October, you'll get a trial date. But this law has decided to make it even worse. Remember the 3-day notice, demand notice you had? It's no longer 3 days. 7-11, 14 days. So now you're serving a 5-day notice saying, hey guy, you didn't pay the rent. Okay, come on. I feel like Sebastian Maniscalco. I don't know if you guys know that comedian, but I was reading this stuff at night, and my wife said, you sound like that comedian. Because all night I'm saying, you can't say that. What does that mean? Are you crazy? But anyway, 14 days now for a demand. So you serve the 5-day notice by certified mail, which, by the way, not to make it more difficult, but you're going to need an affidavit of service of that 5-day notice. Because trust me, when they put in the statute that that's an affirmative defense, what does that mean? I don't know. I don't know. But guess what? We'll find out, won't we? So now you have the 14-day and you serve a notice of demand. What happens after that? You serve the petition. Now the petition now takes 10 days. It's noticed for 10 days. Previously it was 5 days. So they have changed this where you're not in court until a month and a half. And when it comes to holdovers, the holdovers changed from not more than at least 10 days and served at least 10 days and not more than 7 days before you can get 17 days before you can get a court date. That doesn't trouble me that much. What troubles me more is the holdover answer under 743. Used to be, during that great moment of time, that you would get an answer prior to the case, prior to the date the case was on. Now, a tenant and a tenant's attorney can file the answer at the date you come into court. Now, what does that mean? That means not only an adjournment, it means an ambush. Because all of a sudden you're going to get defenses that, if you would have known, you could have prepared for. Whether it's a traverse, whether it's an overcharge, whatever it is, you would at the very least be prepared for it and have a conversation with your client. Now that's not going to happen. And that's a purposeful act. And just going back to 7-Eleven, there's another thing that kind of troubles me, and I'm sure is going to trouble you because it's going to hurt you. If a tenant now dies, and he's the sole person on the lease, and they leave an adult child, they leave a spouse, they leave a recipient of the will in the apartment, can you get rent from them? Not anymore. You get to sue the estate. Now, how many people have had success getting money against an estate? No hands? Ah, look, 1, 2. And you did it for us. Thank you very much. Thank you.
There's a bag at the end of the room.
I got the bottle for you, don't worry. Anyway, but by and large, you don't. And the worst part of that is, not only are you losing the rent that accumulated during the demise of the tenant, but now what do you have to do? You're now stuck with somebody living in the apartment who decides, I'm not going to pay rent, or I'm not going to pay rent until you sue me. Now, could you sue him for the back rent? No, you got to sue the estate. And do you sue a non-payment? Take a non-payment against the tenant? No, because that would be too easy, wouldn't it? You have to then sue for a holdover, in a holdover action. And then at that time, that particular person will decide, I want to succeed to the apartment, or I want to move. But guess what? Whichever way, you're going to get stuck with a loss. And this was considered by those people in Albany and those people who wrote this statute how to hurt the landlord, because there was no reason for this. Now, the other thing is, if a tenant, for example, it used to be if a tenant was late in rent, you sued them, they came in, they said, hey, I'm going to pay the rent. You said, okay, but I want my legal fees. All right? Or I want all the rent. Today, under 731, which is a little ambiguous, it says, in a non-payment proceeding, a tender of the full payment of rent to the landlord at any time before the hearing of the petition must be accepted by the landlord and dismisses the proceeding. Now, here's a question for you. What does full payment of rent mean? To me, it would mean all the rent owed right to the date. Anybody disagree with that? Guess what? I don't know if that's going to be upheld or that's going to be followed. What it could mean is the rent in the petition. Now think about it. It's probably 2 months later, maybe 3 months later, and the tenant comes in with the rent in the petition. Is that fair? No. Are we talking fairness? No. Are we talking about what do we do? Yes. Do we know what to do? No. So that's another one of the questions that which we'll determine and find out what's going to go on in court. Now, there's also the idea about the rent deposit. Years before, Bob Goldstein up in Albany, Ribney, RSA fought to have rent deposits. Yes, you can fight for rent deposits. You can fight for rent deposits pretty much on the second adjournment, or 60 days, or after the tenant asks for an adjournment to see whether he can get an attorney or not, and that's 14 days, but that doesn't count. Am I confusing you? Of course I am. All right, now, what happens if you have hit all the boxes, and and the judge says, make a rent deposit, pay the landlord. I tell you, you have to. What happens if the tenant doesn't? There was a time, it was a beautiful time. You could strike an answer, you can get a judgment. Not anymore. Now they tell you, what can you get? You can get an immediate trial. What is an immediate trial today? What is it? Tell me, somebody please tell me what an immediate trial is. What it is you're in a conference part, you go into the trial part, and the judge says, okay, you're supposed to get an immediate trial. We have to have a PC conference first. That's 3 weeks from now. I don't really have that much time because it does say immediate trial or when available. So it is June 27th. Come back for the conference July 15th, and I can see on my trial calendar, I'll see you in September like the song says. And that, unfortunately, is the real world in landlord-tenant. And not to worry, because the tenant also has defenses against the deposit. They are jurisdictional defenses. The petitioner, and these are allegations, by the way. Petitioner is not a proper party. I've been actually or partially evicted. I have a defense based upon 143B of the social service law. There are hazardous or immediate conditions that I'm alleging. There's a colorable defense of overcharge. I like that. Also, when calculating what the tenant should pay, if they're on certain rent subsidies, they pay a third of their income, which means you're not getting all the rent. Which also means when you make this motion, you're really just making this motion, which unfortunately you're going to have to, is to just try and get the case to trial. That's really what this is all about. Now, there's one portion I want to discuss because I don't want to forget about it, and that is the wrongful eviction, the unlawful eviction, where the newly created section of RPAPL, I'm sorry, I'm jumping ahead, 768, creates cause of action for criminal offense of unlawful eviction using threatening force, course of conduct interfering with, intended or interfere with the ability to use the dweller, owners required to restore the person unlawfully removed under this section upon request. Now, why would I be troubled by that? I'm going to tell you why, and that is the situation regarding the Airbnb use of apartments in the city of New York. Because I believe this is a very dangerous statute, the way they're going to use and try and fine landlords. Right now, if you have a tenant who's utilizing the apartment for Airbnb, you can get fined $1,500 a day. It's almost a strict liability. They're not fining the tenants for doing this. How many people have seen tenants getting fined for use of Airbnb? There you go. No hands. But landlords are getting fined. And the only way to stop that is not just to bring a holdover, but sometimes to stop the guests from coming into the apartment. And prior to this law, it was very easy, as Gilead would remember, we used to stop them at the door. They weren't tenants. It was an illegal act. Go ahead, call the cops. And we were pretty successful with that. What frightens me now is I can't give that advice. I'm not sure what the advice to give, because I don't want to see my clients, I don't want to see you get criminally charged. I don't want to see you get fined. But at the same time, it is a Hobson's choice, isn't it? So you got to be very mindful of that. And
And let's talk about the other thing that's also, when you finally get your warrant, you finally got your warrant, I'm gonna do an eviction. The tenant hasn't paid the rent. Tenant comes in, anytime after the warrant is issued, you have to take the money. There was a time, that beautiful time, when you got a warrant and the landlord-tenant relationship no longer existed. Once you got that warrant, that was it. That was the law. They have codified, it is no longer the law. So at any point, at any time, even after the eviction, the landlord has got to take the money and let the tenant in. This is after, and that's what a judge will rule. The judge has all the discretion. I'm sorry. The judge has all the discretion when it comes to a warrant. And that puts a great burden on landlords to litigate the non-payment cases to its fertility, to its end, to get a warrant, to do an eviction, and what happens afterwards. You will have to take the rent, and not just the legal, and not the legal fees, the rent. So, unfortunately, like I said, this is a very hard time for landlords because you have to bring the action. You can't let it go because if you let it go too long, it's laches. So you have to bring the action, but be mindful that you may be putting them in even after the eviction. And the courts now have more discretion than any time before. Even in a holdover, and you have a decontrolled apartment, it was a time where the landlord had, the judge had discretion to allow 6 months. And normally they would say, okay, 3 months, and then come back in 3 months if you're really having a hard time. Today, now they have a year. They have a year premised upon not only just serious illness, an exacerbation of an ongoing condition, but even a child's enrollment in school. So, as well as, and this is a catchphrase, any other extenuating life circumstances affecting the ability of an applicant or applicant's family to relocate and maintain a quality of life, such as you can't find the yoga instructor that you really like. So these are the matters in which you need to read up on. The summaries that you have, please read, please look at it, study it, ask questions, and hopefully we'll all get through this.
Thank you, Todd, for the comic relief. The changes that have been made that Todd mentioned are incredible when you consider the fact that the title of the section of the laws that have been changed is called Summary Proceedings. There's going to be nothing summary about these proceedings anymore, and that's the sad fact. And when you take into consideration just one thing that Todd didn't mention, and I will mention, and that's this. Originally, the law, for as long as I can remember, probably 60, 70 years, they had a provision that said the court could not adjourn a summary proceeding for more than 10 days. Not more than 10 days. Now, of course, they never followed that, but at least they understood that they weren't following it, so they didn't go crazy. Now, the law provides that if either the landlord, oh, thank you very much, or the tenant requests a first adjournment when the case is on, the judge has to give at least 14 days. And it doesn't say anything about how long beyond 14 days. So that's just an indication of what's probably going to happen. David, you're next? Okay.
So I'm here to try to give everybody a ray of sunshine. I'm talking about the commercial aspect, how this law, if at all, affects the commercial. So how many people here have or manage a property that has commercial units in it? Okay? So the good thing is this statute didn't use the curse word commercial rent control. It's not anywhere near here. It wasn't. It may have been discussed. It didn't make it in here. So far, fortunately, we don't have that issue here. And really, if you're property owners and you have commercial, that's really where you should be focusing, if you can, on your profitability, because it hasn't been touched. We're very fortunate. Last month, there was a big case that came down from the Court of Appeals called the Redbridge case. It basically said that a lease should be enforced as it's written, and it really was a real shot in the arm for landlords. So at your initial stage of when you negotiate a lease is the time you got to make it as powerful as you can, because that's where your profitability is with regard to commercial tenancies. So my partners, both Lester and Todd, who I cannot compete with, spoke a lot about the changes. There you go. I handed out, everybody should have a handout. I'm going to try to be very simple as I possibly can. The good thing is, a lot of the changes here do not affect commercial tenancies and lawsuits that are being brought by a commercial owner against a commercial tenant. That's very important. There are procedural changes here that do impact, and they're going to be the same whether it's residential or commercial. So I'm going to follow seriatim, pretty much the changes in the legislation and the statute. Real property law 227E. Landlord does not have to mitigate damages in a commercial tenancy. You're very fortunate that this firm won a very famous case in the 1990s, Holy Properties versus Kenneth Cole, and that case held that the landlord doesn't have to mitigate damages, and that's the current state of the law, and fortunately, the way it is right now, it's still the current state of the law. Real property law 232A, the cleanup bill, that's related to month-to-month tenancies. Lester talked about 30, 60, 90, right? So we're very fortunate. The cleanup bill, which was just signed this week, June 25th, 2019, excluded commercial tenancies. So now, if there's a month-to-month tenancy, you could serve a 30-day notice of termination, just like we did in the past. So regarding commercial tenancies, you don't have to worry about 60 or 90. It's 30 days, month-to-month tenancy. Real property law 232B, which talks about outside New York City, there also actually does include, talks about, it's actually one-sided. It said the tenant can give the 30-day notice. It doesn't say anything about the landlord. But fortunately, if you look at the handout, or actually there, it talks about, they carved out an exception for the landlord, still 30 days if it's a month-to-month tenancy, even outside of New York City. Real property law 234. We heard the sad news. If you bring a lawsuit for collection of rent in a residential case, you can't include legal fees. Doesn't imply commercial. You can sue for all of the additional charges that you're entitled to under your lease in a proceeding in the civil court on the housing, the commercial division of the housing part, for any of those charges that are in your lease, including legal fees. Real property law 235. The duty to provide a written receipt does not apply to commercial tenancies. That's one less thing of administration that you got to worry about with regard to your commercial tenants. Real property law 235 ED. Now I know this was touched on by both Lester. Lester talked about it. This is the 5-day notice that has to be sent by certified mail. It's not clear whether it applies to commercial. We have taken the position that it does. Why? Because we understand it's an affirmative defense that could be raised by a tenant in a lawsuit. It doesn't say it can be raised by a residential tenant, it can be raised by a tenant. So we're taking a very conservative approach and feel that at this time, until it's been cleared up later on, either by the legislature or by the courts, that it's prudent for a landlord, commercial landlord, to do the same. I just want to say, I heard this past week there was a judicial conference, and this statute obviously came up, and the truth is, even the judges are like deers in headlights, because it's not clear to them either how all this stuff is going to be applied. There are many questions, and there could be many answers. It's all learning experience for all of us, but you're very lucky. You're surrounded by a lot of talented lawyers with many, many years of experience, and feel free to tap into that experience. Real Property Law 238A. It's a new statute that imposed limitations on fees that can be sought in some proceeding. Does not apply to commercial. As I said before, go for it. Whatever additional rents you're permitted to collect in a commercial tenancy, you could sue for it in the civil court, commercial division, part of the housing court. Real Property Law 711-2, which talks about rent demands. There was a change which does apply to commercial. No longer an oral demand, not that you would do in a commercial anyway, do an oral demand, but now the rent demand is no longer 3 days, it's a 14-day rent demand. That applies to commercial as well as residential. Real Property Law and Proceedings Law 733-1, service of a holdover, both residential and commercial, has been changed to add more dates. It's not less than 10 days and not more than 17 days. Again, it's applicable across the board, whether it's commercial or residential. Real Property Law and Proceedings Law 731-4. Again, a new subdivision that was added. It talked about a non-payment case when the tenant pays the rent, pays the full amount. I actually have it quoted here. Any time prior to the hearing on the petition shall be accepted by the landlord and renders moot the grounds on which the special proceeding was commenced. Unfortunately, this provision does apply to commercial. I don't see an exception here, and unfortunately, if the tenant pays the amount, and I'm going to go on a limb here, I would think it's whatever you're suing for in the petition. I know we want to be able to push the envelope and argue that maybe it's all the rent that came due up until the date that the tenant paid the rent. I think this is a knee-jerk reaction to the fact that, you know, landlords always insisted, I want all the month that's due through this date, and there were judges out there specifically in the residential part said, no, I'm only giving you through the petition, counsel, they satisfy the petition, start a case for the rent that accumulated after the fact. I think that was the reaction here, and my intuition is saying that if they pay the rent in the petition, the case has been satisfied and rendered moot, and the language is quite specific. Real Property and Proceedings Law 732, proceedings brought for non-payment, whether commercial or residential, require, again, a minimum 10 days notice. It used to be 5 days, now it's 10 days. Real Property Law 732-3, again, changing the time, 10 days before default. It used to be 5 days. If the tenant didn't answer, you could get a judgment on 5 days. Now it's 10 days. 743 of the RPAPL talks about the answer. I know Todd spoke about it, that, you know, they can now answer orally or in writing at the date that they're in court. They deleted the specific language that provided that you were entitled to notice 3 days in advance. That obviously hurts commercial cases as well to delay the process. I always advocate, certainly in a non-payment case, when you get your answer in advance of the return date, because the clerk sets the date. In a commercial setting, if you have the ability to make a motion for summary judgment to strike defense, that you do so. In a commercial avenue, the civil court's more likely than not to grant your motion if there are no material issues of fact outstanding and the landlord's able to recover summary judgment on the issue of rent. And it behooves you to take advantage of that fact, certainly in the residential. Obviously now in the holdover, you're not going to have that luxury of having the answer in advance because the tenant doesn't have to come to court with the answer until the due date, and you could be sure that the next paragraph talked about giving extension of time for an adjournment was also put in there so that if the tenant doesn't show up with an answer on the return first date, that they automatically have an adjournment for a minimum of 14 days. RPAPL 745 says the judge shall, doesn't make it discretionary, shall adjourn for a minimum of 14 days. So if there's an application, minimum adjournment now is 14 days. And then on a second application, there it says now it's discretionary. The court can decide whether it's granted it or not. I also want to comment that with regard to the rent deposit law, it does apply, as far as we can see, to commercial tenancies, but as I just recommended before, if you have the ability to make a motion for summary judgment, I would do it. It would obviate any need with regard to the rent deposit issue. 749 talks about service of a marshal's notice. We really didn't touch on that, but now, instead, it used to be 3-day marshal's notice, 72-hour notice, and then it went to 6 business days. Well, now that notice is 14 days. We've now pushed back the ability to obtain legal possession, and that applies whether it's residential or commercial. Real property law, RPAPL 749.3, which talks about the stay of an eviction after a judgment has been issued. Unfortunately, this applies both to commercial and residential. It's very important to know that now the court has the discretion, whether it's commercial or residential, to grant a stay beyond that's in the statute. And, you know, there's also a modification of the statute that if the tenant tenders or deposits the full amount of the judgment at any time prior to the execution of the warrant, can't evict anymore. And it says the exception is, and this is a new exception that was created in the statute, if the landlord establishes the tenant withheld the rent in bad faith. Good luck trying to prove that, but they threw you a bone. It's there. Maybe we have the ability to use that at our disposal. My only closing comment is don't have despair. We have vehicles at our disposal. We have intuition and intelligence, and that's what we should use to get through this together. Thank you.
I only have one comment, and again, most of you probably realize that there is pending in the City Council a bill to mandate arbitration and lease renewals of commercial tenants. Whatever you need to do to try to impact on the City Council to not pass that bill, if you have commercial properties, you know, even limited as part of the residential, do it, because that bill could become law. Now, Carla, you're up now.
Good morning. I'm dealing with security deposits. Thanks. At the outset, please be aware of the fact that there seems to be an ambiguity in the law in terms of the intentions. Oh.
No, they can't. You got to speak out into the mic.
Can you hear me now? All right. So it appears that the intention of the law was to cover non-regulated units. However, that law then refers to the exception rent control, and then refers to a section in the GOL that basically deals with rent stabilized tenancies. So our position is that unless or until there's a clarification or a final determination, you should follow the new rules under security deposits. I want to highlight 3 things. You can follow the track, the slides follow the law, but I am going to deal with 3 issues. One is that the return of the security deposit must occur within 14 days of vacature. Secondly, can you hear me? All right.
I don't want to hear that, but they heard it.
Secondly, there's another subdivision which deals with a pre-occupancy inspection and a vacature inspection. And then the third aspect that I want to deal with is what's called the advance. Because under the law, you cannot accept more than 1 month's rent as security or an advance. And in many situations we have where there is a tenant that's kind of iffy and you ask for an additional rent, or you ask for the last rent to be applied, the rent to be applied to the last month, that's no longer acceptable, because the statute specifically says no deposit or advance shall exceed 1 month's rent. What? The second aspect, which I'm going to read with you, deals with an inspection once the lease has been signed, but before the tenant takes occupancy. They require, and the language is clear, as we've said before, it's shall, which means it's mandatory. And the law states that after signing the lease, but before actual occupancy, landlord shall offer the tenant an opportunity to inspect the premises to determine its condition. Now, if the tenant wants to inspect, the parties are to execute a written agreement before the tenant takes occupancy. By the way, everything's in writing. Every burden that's the landlord has to be in writing. When they inspect the premises, they want to see the condition of the property and specifically note any existing defects or damages. And the purpose of this is so that when the tenant vacates, you can't use this against the tenant in terms of retaining any of the security deposit. Also, this agreement can be used in relation to any litigation regarding the security deposit. So presumably it can be used in an HB proceeding or in a traverse hearing, but solely when your tenant sues you because you haven't given him the entire security deposit. Then there is the pre-vacature inspection. The law is very clear, not more than 2 weeks and not less than 1 week. You have to notify the tenant that he is entitled to an inspection. I say he or she. And that is also an obligation on the landlord's part. When this happens, you have to give the tenant 48 hours notice of the date and the time of the inspection. Once the inspection occurs, the landlord has to notify the tenant in writing as to what he claims are the repairs that will be the basis for the deduction of the repairs. Again, the purpose of this is to eliminate any reduction of security. So once you notify the tenant has an opportunity to cure. So at the end, if he cures, he's entitled to his entire security deposit. All right, so it used to be that the security deposit had to be returned within a reasonable time. Now the law requires that it be returned within 14 days. There are some penalties for that. When you return the security deposit, you have to have not a sworn statement, but an explanation as to why you retained a portion of the security deposit. The failure to include that makes you forfeit your right to any portion of the security deposit. In addition to that, if you don't return the security deposit and it's challenged, you will be subject to actual damages. So your tenant can sue you for that. And if it's willful, it would be punitive damages, and the damage is calculated at twice the amount of the security deposit. And also, if the tenant gives you less than 2 weeks' notice, none of these situations apply. He has forfeited the right to get the inspection, etc. Under the law, as amended, it says the entire amount of deposit is refundable when the tenant vacates, except when there's a reasonable and itemized cost due to non-payment of rent, when there's damage caused by the tenant beyond normal wear and tear, and of course, because you have the sworn statement and you've done the inspection, you'll know what's beyond normal wear and tear. When the moving and storage of the tenant's belongings is involved, and when there are those types of agreements when the landlord's responsible for the utility bills. In those instances, you can reduce the security deposit. And I think that's it.
Thank you, Carla. I have just one addition. I have just one addition that I want to just touch on. That's going to become a question that we don't know the answer to. Surprise, surprise. Number one, letters of credit. Okay, it would appear that that concept is threatened. Okay, two, obviously the advance payment of other months' rent, that's out. And then the only other question that I have to pose is, are the insurance companies that are now writing renters insurance and the tenant is being forced as a condition to getting the apartment to pay the premium on that renter's insurance, are those going to be attacked as being something not authorized by the law, which is very strict in terms of what you can do in terms of the screening process. Remember, you can't use screening processes anymore that refer to court records. And the companies that sell this are not going to get access to those court records for the purpose of you using them to determine whether or not you want to use a tenant, you want to rent to a tenant or not. I mean, this is unbelievable that we have an area of the court system which is being closed off to the public, right? So if you rely on something like that and then the tenant doesn't get the apartment, you better have other reasons why you didn't give the tenant the apartment. Whatever your criteria is, right? You can't use the credit reports that refer to the litigation experience of the tenant. The question that we're raising internally is whether or not there's a possibility that our records as to what we do not in court, having to do with the processing of the three now 14-day notices, will be something that you could access to know that this tenant had been a habitual late payer of rent and whether you could use that. So we're going to explore that, and there may come a time when all of the practitioners in some way pool that information, because it's not information from the courts, but it's information from the individual lawyer's records, and it's not a court case, it's the 14-day notice. That said, I think we've concluded. We've concluded that portion having to do with residential buildings, and we're going to move on now to the final section that we're going to talk about, which is Eric Goidel's section on the co-op. And
good afternoon. I know we're about an hour over, so I'm going to be very brief. Thank you all for coming again. So a couple of years ago, we knew that this legislation was coming. They telegraphed their punch. We just didn't know that it was a knockout punch. But over the last couple of years, I've had a number of conversations with clients, and they said, well, we have this fail-safe mechanism. If they really do, hand us something that we can't handle, we'll just co-op or condo our buildings. Unfortunately, at this time, they took away a lot of those rights. So prior to the law coming down 2 weeks ago, there was a fairly easy ability to convert buildings to cooperative or condominium ownership. There was a eviction plan available, which was seldom used because it required 51% of tenants in occupancy, your existing tenants, to subscribe or execute purchase agreements. But there was this non-eviction plan concept which was available, which only required 15% of the apartments to be subscribed for. And that 15% could be 15% of anybody. It could have been 15% of your existing tenants. It could have been outsiders purchasing a vacant apartment, or it could have been outsiders purchasing an occupied apartment subject to that tenancy. And then add to that the fact that under the Attorney General's regulations under the Barton Act, you're allowed to warehouse up to 10%, essentially up to 10% of the apartments. So you're already 2/3 of the way with warehousing. You were 2/3 of the way to your 15%. So it was a very simple exercise. So the legislature 2 weeks ago basically eliminated the conversion, what I would say basically eliminated the conversion of occupied residential housing to cooperative or condominium ownership by first eliminating the whole concept of the eviction plan. And as I said, that was seldom used, seldom successful. But what they did was they basically turned the rules for a eviction plan into the rules for a non-eviction plan. So now you have to get 51% of your tenants in occupancy to subscribe or execute purchase agreements to declare a plan effective as a non-eviction plan. And that is probably virtually impossible. The only way it might be possible is if you're going to have I'll call it a fire sale of your apartments by offering such a low insider price that a residential tenant who has all the protections that everybody discussed today behind them would make the business decision on their own to subscribe to an apartment. So basically, I would say that the number of co-op apartments in the city of New York basically became fixed as of June 14th. There really are no new construction cooperative developments to speak of. There are new construction condominium developments that are being built, but co-oping is probably over and done with. Now, the other issue is, though, if you are trying to co-op your building, you cannot offer an apartment to an outsider for 90 days for the exclusive period that the tenant in occupancy has a right to purchase. Then, to add insult to injury, though, if you were getting close to that 51% and you wanted to sell some apartments to outsiders, and presumably those are not only the warehoused apartments, but maybe some of the occupied apartments, the insider tenant, your rent-regulated tenant, has a right of first refusal for a period of 6 months after the end of an exclusive period to match a contract that you have signed with an outsider. So it effectively killed the ability to sell occupied apartments as part of a conversion too, because presumably you're selling that at a substantial discount because it's subject to the tenancy. So now they exercise the right of first refusal. They're purchasing subject to their own tenancy at a deep discount. And the other thing I wanted to repeat, which is what I think Bob mentioned, which this was kind of, I don't want to say buried because it was in Part K, but that dealt with rent-regulated apartments. A co-op building which has some rent-regulated apartments, but less than 35% of the rent-regulated apartments, where the unsold shareholder holds that, you will not qualify for applying for major capital improvement increases. So when a roof is put on by the co-op board, a new elevator, and you own less than 35% of the units, or the shares allocated to 35% of the units, that will not be allowed anymore. Some takeaways here. As I said, the conversion of existing buildings is probably now history, and the number of co-op apartments in the city of New York has probably peaked. And the only new construction you're going to see is under the condominium regime. The value of the unsold units may be affected positively or negatively by issues such as the availability of the MCIs. But one thing is, I view the unsold co-op apartment as ultimately the only one of the few pure plays left in New York City for residential housing. Now, you will have a rent-regulated tenant perhaps in the apartment for some period of time, but the rent stabilization law specifically exempts from coverage buildings occupied as a cooperative or condominium. So once you have that vacancy that occurs, you have a truly deregulated apartment. So I would say that the value, while some of the apartment building values will probably be dropping because of this legislation, unfortunately, the value of unsold shares, unsold condominium units will probably be increasing. Thank you very much.
That concept is for the gamblers in the house. Again, and to end on a note, what they didn't change this time, right? You can be sure they're going to be thinking about how they can put it to people who are either sponsors or holders of unsold shares who may own more than one apartment. In other words, they'll figure out that if you own a bunch of apartments, maybe they'll change the law by next year. Hopefully not. I want to thank everyone, especially the people, from my office who helped put this together, and of course, more than anything else, the clients and their friends and other people who came to listen to what we had to say. Unfortunately, we're not going to have time for any questions and answers now. Please, write out a card, leave your business card with the index card, and we will definitely get back to you with answers to the questions, or at least telling you so that you can chuckle that we don't know. Thank you and have a very, very nice day.